Appeal and for the 5th District of the State of Florida is now in session. The Honorable Rand Wallace, Judge, presiding. All persons having business with the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to a day of oral arguments at the 5th District Court of Appeal. Before we begin, I'd like to introduce the panel. You've already, my name is Rand Wallace. To my right is Judge Brian Lambert, and to my left is Judge James Edwards. We have 2 civil cases on the docket today. Before we begin, if anybody has any noise-making devices, phones, iPads, please silence those so that it's not disturbing the lawyers or distracting during the oral argument. You have 20 minutes per side. I'm going to assume that the appellant wants 5 minutes of rebuttal time unless you tell me differently. And then with that, the first case that we have on the docket is the Rivera versus Orlando Health case, and the appellant may begin when they are ready.
May it please the court. Good morning, Your Honors. My name is Daniel Ostendorf, and I'm with the law firm of Party and Rodriguez, and we represent Martin Rivera in this appeal. The issue before the court today involves the interpretation of Section 76879 Florida statutes, the offer of judgment statute, and what we contend was the trial court's error in failing to strictly construe the statute and apply its unambiguous terms to the facts of this particular case.
Mr. Ostendorf, does 768.79 expressly prohibit the trial court from considering the effect of a fee agreement on the actual amount that the trial court awards?
Not expressly prohibit, Your Honor, but it expressly states what a trial court is to do when evaluating the manner in which to impose sanctions against a party who has failed to accept a presumed reasonable offer. Specifically, the statute states that if a prevailing party is determined, entitlement is determined by a trial court, then attorney's fees are to be imposed from the date of the offer forward. This is important because 76879 is the only statute in Florida that has this particular type of language that tells the court exactly how to determine what the appropriate sanction is to be levied against the non-prevailing party, in this particular case, Orlando Health.
So the attorney fee contract's irrelevant?
Yes, it is. Yes, and the reason it's irrelevant, Your Honor, is because the attorney fee contract is the relationship between my firm and our client. 76879 is a penalty. The Supreme Court in Sarkis versus Allstate, which is cited in my briefs, specifically stated and did an extensive analysis of the history of 76879. And in that opinion, the court states, quote, "This is a sanction levied against the rejecting party for unnecessarily continuing the litigation. The statute specifically limits the attorney's fees incurred after the date of the offer was served upon the rejecting party." And then importantly, the Supreme Court tells us the right to the award of attorney's fees attaches to the rejection of the offer of judgment, not to the cause of action. So
You get around the Roe case.
Your Honor, you don't have to get around the Roe case. The Roe case actually, as is stated even more succinctly in my reply brief, the Roe case, first of all, predated 76879 in its current form. So Roe did not analyze the language in that statute. The Sarkis case did, which came after Roe. But Roe tells us that to determine what the appropriate amount of sanction is to be levied under 76879 is simple. You figure out what the reasonable hourly rate is, and then the court determines what the number of hours that were reasonably incurred from the date of the offer, just like the statute's language says. It's as simple as that.
Counsel, are there any cases that agree with you that say the fee agreement is irrelevant
There's no cases that agree with me on point, but, Your Honor, more importantly, there's no cases that disagree with me. There isn't a single case in the state of Florida that discusses how 76879 is supposed to be applied in connection with a fee agreement. Every case relied upon by the appellee has to do with a totally different statute. Every single one.
But similar schemes in terms of fee shifting, wouldn't you agree?
No, I don't agree at all, Your Honor. Actually, they're quite different. For example, the fee-shifting statute under the medical malpractice statute, under like the Lane v. Head, for example, or the other case relied upon, the Miami Hospital case relied upon by the appellee, those are not mandatory fee-shifting statutes. They're potential fee-shifting statutes that are in the discretion of the trial court based upon the facts and circumstances of each of the cases. Why does that matter?
But 76879 is not a mandatory fee shifting. I mean, there's still a good faith analysis. I mean...
Actually, it is, Your Honor. I would disagree with you there. It is a mandatory fee-shifting statute. The language itself specifically states that you shall be entitled to attorney's fees. Shall has always been interpreted by the courts of the state of Florida as being mandatory. That is black-letter law in the state of Florida. It has been for a long, long period of time. So I would say to Your Honor, it is a mandatory fee-shifting statute subject to a good faith requirement. And it's a very simple analysis under 76879, which is, did you make a proposal for settlement? Did you go to trial and prevail or get a judgment that's 125% of the amount? And if so, entitlement is done. That's it. And then the rest of the statute says you go back to the date of the offer and put the attorney's fees from that date forward. And why does that matter? Because what the trial court did in this particular case is it ignored the language of the statute. And the Supreme Court has told us from years back, the Velez case, again cited in my brief, that the pole star of statutory interpretation is to give meaning and effect to all the provisions of a statute. By doing what the trial court did in this particular case, it ignored the statutory language. It modified and limited my client's right to recover attorney's fees as a sanction from the appellee, Orlando Health. It's precisely what happened in this case. And then the trial court compounded that by misinterpreting and misconstruing our fee agreement in and of itself.
How did the trial judge do that? Sounds pretty clear.
Because, Your Honor, what the trial court did is it reviewed two cases that were posited by Orlando Health to say that in order for there to be a imposition of a fee in excess of 40%, two words were necessarily to be required in our fee agreement, the words greater than. And if you look at the law of contract interpretation, that's not necessary. When a court construes a contract, an unambiguous one, and we consider this as an unambiguous contract, the courts are required to simply look at the contract and, more importantly, look at the contract in context. What is the language that we're looking at, and what is its purpose if it can be gleaned readily? And it can in this case, because our contract specifically says that we agree that the attorneys are entitled to receive the total fee incurred according to any fee award, and that we have an obligation to go after that fee from the defendant if we can. So the obligation is to pursue the fee, and then if the court awards the fee, we get the total fee awarded.
So if there was a different fee-shifting statute that it's not a sanction, using your term today, it's just a fee, the prevailing party gets fees, and this is your contract, you're saying that the losing party in my hypothetical would arguably have to pay more than 40% of the net judgment?
Yes, absolutely, Your Honor.
Contract, even though Roe would say you can't go beyond the express language of the contract?
I do not believe that Roe says that, first and foremost. There's no language in Roe that says that, because if you look at Roe, Your Honor, the language that's relied upon by the appellee and the language relied upon by the trial court specifically ignores the two sentences that came right before that, which state, Your Honor, that in interpreting and awarding fees under Roe, the court cannot simply look to the terms and conditions of a fee agreement, because to do so, and this is in my brief, Your Honor, to do so ignores the facts of the case. It can't be the guiding principle, because what the court in Roe was talking about were the attempts by attorneys to artificially inflate their attorney fees by putting in exorbitant fee rates per hour or something like that.
Right, but doesn't Roe and the cases that come after that say it can never exceed the agreement between the parties, and that's why so many attorneys after Roe put in the greater than? I understand what you're saying. In your opinion, those aren't magic words. Apparently, to some courts, those are magic words, but I mean, that's why they do it. They put that language in there so that the court can't exceed the 40% or the 33 1/3 or whatever it is.
What I would agree, Your Honor, is that the cases that came after Roe have stated that you have to have that additional language, and they also have stated that you have to use the fee agreement. None of those relate to Section 76879 Florida statutes, not a one. And the reason is it's a different statute. And to come back to what you said, Judge Lambert, it's not my words saying that 76879 is a sanction. It's the Supreme Court of the state of Florida in Sarkis versus Allstate. They describe this statute as a sanction. Think of it this way. If the losing party or the non-prevailing party in this case is to be sanctioned, why do they get the benefit of some analysis of a separate document? The purpose of the sanction is to punish the non-prevailing party for continuing its litigious conduct.
Well, they are being punished. They're paying an additional $32,000 in attorney fees where if there was no 76879 proposal for settlement, they wouldn't have had to pay that. So
Right.
that's the sanction.
But what they're not doing is they're not being punished and they're not being penalized or sanctioned according to the express terms of the statute. The statute says that they're required to pay reasonable attorney's fees and costs from the date of the offer. And if you do the Roe lodestar analysis, there's an easy way for trial courts to calculate that without reference to any other document like a contract. It's simply an affidavit of fees to be supported by expert testimony. Another point in our brief, which is the trial court in this case did not award expert attorney's fees to the expert that testified at our fee hearing.
Well, as to that point, don't we have clear case law out of this court that says you do not award expert witness fees, tax those as costs when it's simply as to the amount, litigating the amount of the fee?
But, Your Honor, in this particular case, that's not what transpired.
Don't we have that?
There is case law that says that.
You agree with at least that part?
I do, absolutely. But in this particular case, they didn't stipulate to attorney's fees until the moment we walked into the hearing. The expert had already done his work.
No, I understand that, but in all candor, I looked at those sections of your initial brief and your reply brief. I saw no citation to any case, statute, or rule that would give you the expert witness fees under there. I understand your argument very well, and again, logically, it makes sense that if you have to have an expert, maybe you ought to get the cost, but the case law is all against you on that, isn't it?
I wouldn't necessarily say this case law is all against us, Your Honor. I mean, if you look at the...
Well, if you got a case in your favor on that says under these circumstances you get your expert witness fee when the only issue is the amount.
See,
Tell me what that case is, because I don't see it in your brief anywhere.
we're taking aside, my expert witness was engaged, did his work, showed up at a fee hearing, and then as we were literally walking in the door, the appellee, in this particular case, conceded entitlement. He's already done all his work.
Well, is there anything in the record that splits up how much of his time was for entitlement versus how much was for what a reasonable amount of hours and a reasonable fee is?
I'm not sure if it's specifically in the record, Your Honor. The fee hearing lasted approximately an hour and a half of the 7.5 hours of time that was testified to.
How would entitlement, I mean, from what your earlier argument is, it's simply a mathematical computation, so how would entitlement be a disputed issue that your attorney, your expert would have to prepare for?
Because, Your Honor, entitlement is not determined until we actually had a hearing on the motion to tax attorney's fees and costs, unless there's a stipulation before the hearing that allows the court to simply go to amount. In this particular case, the appellee, because we had to wait months to get our fee hearing, had more than ample time to stipulate to entitlement, never did so.
But my point being is, what analysis would your expert have to do to say, well, in my opinion, plaintiff's entitled to fees, because you're saying that all you'd have to do is look at, here's what I got, here's what my offer, clearly I've met, the criteria, so Now we're just really talking about the amount, aren't we?
Right, we are talking about the amount, Your Honor, but the expert witness has to come in and testify as to whether or not they think the amount is reasonable. I have to support that under the Nance.
That's the amount. You're talking about the amount of your attorney fees. You're not talking about the entitlement. In other words, he doesn't have to analyze, boy, I wonder if my testimony be persuasive to the trial judge to convince him or her that plaintiff's entitled to fees.
Actually, I think that would be...
entitled to fees.
It would be improper expert testimony, Your Honor. It's an issue of law to be determined by the court. I don't think it's the proper subject for expert testimony.
Right, yeah, right.
No, but what I'm saying is that even if I have to go to a fee hearing and there's a dispute over reasonableness, the law still says I have to support that through expert testimony.
I understand that, too. I get you on that. And like I
Okay.
said, logically, I understand it and can follow that argument. My point is this: if you've got a case that's contrary to our Seminole County case that says you do get the expert fee, you
Fair
better
enough,
tell us
Your Honor.
about it, because right now, everything's against you on that point. I understand your logic.
Fair enough.
And we understand Markham v. Markham 30 years ago says you got to have an expert witness. In those cases back then, you don't now. Ironically, I was actually the trial attorney in Markham.
Your Honor, I don't disagree. I think it's ridiculous that an attorney can't come in and talk about the services that be provided, and the court can't determine in and of itself what it is. But however, the procedure has been and continues to be that an expert witness usually comes in and provides expert testimony, and that candidly, in my experience, more often than not, that expert witness is compensated as a taxable cost under the Uniform Guidelines for Taxation of Costs.
Seen it too, but how it happens is something of a mystery, but in terms of cases and statutes and rules, how about go to the prejudgment interest, the pre-award interest?
Yeah, and briefly, Your Honor, and I'm at 5 minutes, so I'd like to make sure I reserve enough time, so if you'd like, I can take that up when I come back.
That's fine.
All right.
May it please the court. Good morning. My name is Sharon Henry. I'm with the law firm of Mateer Harbert, and I represent the Appellee Orlando Health in this case.
Well, let's follow up with the prejudgment interest. I'm curious. Am I misinterpreting what was said in some of the submittals? Did Orlando Health tender the $32,702.61 plus prejudgment interest at some point?
We tendered attorney's fees and costs and agreed upon amount of interest from the date of the judgment until the date of payment. So we have not tendered prejudgment interest.
I'm sorry, I didn't understand that. There were, in November of 2012, there was a stipulation as to entitlement.
Yes, sir.
Was the stipulation that the entitlement was the 40% of the judgment?
No, sir. The stipulation was that appellant's counsel was entitled to recover attorney's fees.
Was your position at the attorney fee hearing that the amount would be the $32,702.61?
Yes, sir.
Okay.
That it was capped by the language in the fee agreement.
And you didn't really contest it? You weren't arguing that it should be less than that?
That's correct.
Okay, so at that point, on November 12, 2012, that's the number you agreed they should get. They shouldn't get the lodestar figure.
That's correct.
And so, at some point, did you then tender that $32,702.61 plus the 4.75% interest that accrued from that day?
We did, Your Honor. I believe it was after the date of the order because appellant opposed the amount.
Right.
And so when the order was entered and it was determined by the trial court that that was the amount of attorney's fees and costs that was due and owed, we paid it at that point.
So you paid from whatever that date was till the order, I guess, was like a year later entered or something like that?
Yes, sir.
And so at that point, you calculated $32,702.61 plus 4.75% interest on whatever that computes to per diem and said, here's your money for that.
Yes, we
To stop the
did.
meter from running.
And that was an agreed-upon amount with appellant's counsel. We spoke on the phone and did the math together and agreed what the interest amount should be, and that amount was paid.
So I guess in my roundabout questioning here, I apologize for that, that issue is now moot if we affirm in its entirety the order that we're talking about today.
Yes, sir.
Okay, all right, go ahead. Thank you.
I wanted to point out for the court's edification, in response to Appellant's argument, that Florida Statute 76879 includes language that also says when an attorney's fee and cost is being determined, that all other relevant criteria should be considered. So relying on the language of the statute, it is required that the language in the fee agreement be considered as well under Roe. And yes, Roe did predate the promulgation of the Florida statute, but it's been enforced and applied by this court and the Fifth after the promulgation of that statute. And there is no case that says Roe and its progeny does not apply when attorney's fees and costs are being awarded pursuant to 768.79. It's well settled in Florida law that in no case should a court-awarded fee exceed the fee agreement reached by the attorney and his client. The trial court got it right here. The trial court determined that the fee agreement did not contain the provisional language which is required. This court has said absence of the provisional language is fatal. The fee agreement contained none of the greater than or either or language which would permit an award of more than 40% of the jury award. The contract language is clear and unambiguous, and the system worked just as it's supposed to work in this case. Appellant and appellant's counsel got the benefit of their bargain. The appellant received the full value of the verdict. Appellant's counsel received the maximum permissible under the fee agreement, and the deterrent effect of the proposal for settlement statute was triggered because Orlando Health did have to pay fees and costs in excess of the verdict. Everything worked here just as it was supposed to.
I have a question for you. On the fee agreement, I understand the magic words that all the courts look to, greater than, is not in there, but there's the provision in there on the contingent nature of the attorney's fee, and specifically, there's a sentence in there, I understand that a contingency fee multiplier may be obtained by the attorneys, and so on and so forth. I mean, there is language in there that would indicate that they're not trying to limit the fee just to the 40% under certain circumstances, isn't there?
I would disagree with that, Your Honor. If you look first to the front page of the fee agreement, under computation of attorney's fees, it states, as compensation for their services, I agree to pay the attorneys, including any court-awarded attorney's fees, the following amounts, and then it sets out only contingent amounts. It does speak...
Right, but when you get down to, and this is in a separate, it's under the heading of contingent nature of fees on, it's page 443 of the record, but it refers there to contingency fee multipliers. It doesn't use the greater than language, but I mean, there's some indication in there that the client and the attorney have agreed not to limit it just to the 40%. I mean, if there's a multiplier, then they could multiply the 40%, not in this case because it doesn't apply, but by, 1.5, 2, whatever the number was. So they aren't really limiting themselves so strictly as you're arguing, I think, to just the 40%, are they?
I think that they are, Your Honor, even though there is some contemplation of other scenarios that are not applicable in this case. There is no magic language which is required. And specifically looking at the sentence that appellant's counsel relies on, there simply is no language that says greater than, whichever is greater, either or, which would give the trial court the authority to exceed the maximum allowed under this contract. So there is some contemplation of other scenarios, but even arguably in those other scenarios, the trial judge would not be able to exceed the contingency max because the contract does not contain the required language.
Why do you think, kind of following up on the expert witness fee, I mean, it kind of puts people in an odd scenario. If you're at the trial counsel, I need to hire an expert to testify as to fees, reasonable amount of fees, assuming we didn't have the limiting language in this contract that it seems to have here. So that person testifies, they should rightly charge a fee for their expert witness services. Seems like this court's taken the position in a couple of cases that that's just part of the cost of doing business for attorneys, and either I, as the attorney who is hiring the expert, have to eat that cost, or the attorney who's testifying an expert has to basically be doing it pro bono. That, doctors, architects, appraisers, they come in and testify in court, and they charge a fee, and those are routinely taxed as costs. What's the distinguishing event here?
The rationale in the case law, Your Honor, is that that testimony inures to the benefit of the appellant's counsel only. And so properly, that's a burden that he or she should bear, because there is no other purpose for that testimony. That expert witness is testifying to monies that the opposing party should have to pay to that attorney, and because that testimony benefits only that attorney, that's a burden that he should have to pay.
Should it be any different, though, where it's a sanction under 768-79?
No, sir, because the sanction, the impact of the sanction is still triggered. I mean, the attorney is testifying to the amount of the sanction to the benefit of appellant's counsel, but it's still a sanction to Appellee, because Appellee is still having to pay some amount in excess of the verdict, and that's the whole purpose behind the sanction statute.
Does an attorney fee expert ever testify as to issues, and ever properly testify as to issues of entitlement? Or is that just solely always a determination of the trial judge?
I think it's my understanding that there is, on occasion, testimony that may be related to entitlement. Actually, let me take that back. I think that is a determination by the trial judge, because it's really the issue, the scenario where I've seen it come up is whether or not the proposal for settlement is valid or invalid, and that's a determination by the trial court. If there are no other questions, Appellee will rely on its brief.
That's fine, thank you.
Thank you very much for your time.
And Mr. Ostendorf, you have a little short of 5 minutes.
I see that, Your Honor. Thank you.
And I have a question, kind of a follow-up to Judge Lambert's question. So you would disagree that the Roe case stands for the proposition that the Supreme Court has said in no case should the court-awarded fee exceed the fee agreement reached by the attorney and his client. Is that correct?
I disagree, Your Honor, that the Roe case language that's been cited by both you and Judge Lambert under that aspect of the Roe opinion applies in this case. I do not disagree that the case says that, and that subsequent to that, there have been other appellate decisions, both at the DCA and the Supreme Court level, that have latched on to that language as a limiting factor that should be used. But in this particular context, Your Honor,
why shouldn't we follow those cases? There hasn't been a case cited by you that says that we shouldn't follow that aspect of Roe. So tell us now what case law supports your position today.
specifically, Your Honor, the statute itself supports my position unequivocally. Okay, and the Sarkis case, the Sarkis versus Allstate Insurance Company case out of the Supreme Court in 2003, specifically states that the provisions of Section 76879 are a sanction to be levied against the non-prevailing party for its litigious conduct, and that as a result of that particular conduct, the case specifically says that attorney's fees are to be awarded from the date of the offer. That's how 76879 is to be interpreted. The Sarkis case came out years after Roe, years after the other decisions that were cited by the appellee in their brief that talked about the other statutory provisions that are where there's a potential award of attorney's fees, for example, the Med-Mal statute or the FSIPA statute. Sarkis could have said in that opinion, and by the way, you're also limited to the amount of the contingency fee agreement. I'm certain the Supreme Court was aware of its other decisions. It didn't do that. It had every opportunity to do that. Instead, it said, this is how you apply 76879, and this is how the sanction is to be determined. It's as simple as that. And Again, in this particular case, when you have a statutory section that imposes a sanction that has express, clear, and unambiguous language, it's incumbent upon the courts, and the trial court in this case, to have followed that language, and he ignored it. The judge simply ignored it.
I guess it kind of begs the question, the 900-pound gorilla or elephant in the room, since Roe has been around and the plaintiff of bar's adaptation to Roe to avoid the issue that you're facing today, why didn't the contract in this case simply have the standard language that lawyers have used for 20-plus years that says, here's my fee unless I'm entitled, unless the trial court allows me to get more based on some other statutory thing, and then we agree that I get the greater amount? I mean,
Your Honor, I wasn't the author of the contract, but I do believe that the language within the contract supports the award of an attorney's fee based upon the language of 76879 that is far in excess of the 40%.
But clearly, I mean, we can parse words here, but clearly, if you simply had, if whoever the author of the contract had simply put in the, and I mean this in the meaning, the magic words, we wouldn't even be having this discussion today, would we?
Agreed. But they're not there. But their omission doesn't in and of itself make this dispositive of the case and the issues that I've presented before the court on this particular appeal. Again, the language of the contract, taken in context, in accordance with the Heck case and the other cases that talk about contract interpretation, you don't just review a contract in a vacuum. You interpret it consistent with what Judge Edward was talking about. The contract provision that we rely upon that allows us to get a fee in excess of 40% says that we have an obligation to pursue it, and that the client agrees we get the total fee awarded by the court. What other meaning could it have if it's limited to 40%? It doesn't make any sense. You have to review a contract in context and use your common sense in giving it its intended meaning, which is clear on the face of the words. It's as simple as that. In conclusion, we request that the trial court order denying the attorney's fees and costs in excess and its failure to apply 76879 be reversed. We request the expert witness fees for the testimony of Daniel Dill and prejudgment interest from the date of the entitlement which was not paid. Thank you.
Well, I'm sorry, your opponent said that from the date of November 12, 2012 until the order was entered, they paid the fee plus the prejudgment interest.
She paid prejudgment interest from November 12, 2012 until the date the check came in. She did not pay attorney's fees and costs from the date of the judgment was entered and the entitlement to fees was triggered. She waited well over a year to stipulate to entitle, 5 months to stipulate entitlement. So it's a 5-month period of time, which is easily calculable. And in this particular case,
Runs from when, I'm sorry?
the 5 months runs from the date of the entry of the judgment, and then we filed our motion for attorney's fees and costs, and it would run from the date of that, which they didn't stipulate from that.
5-month gap is the gap you're concerned with?
Yes.
All right, thank you.
Thank you. Appreciate it.